I can see people joining in, so we'll give everyone a minute. I know we have participants from Europe, the West Coast, East Coast joining in. So yeah, let's give everyone a few seconds and then we'll get started. Um, with that context, a little, yeah, with that context, a little bit about the webinar. So this webinar is part of a webinar series by Privado, which is on website privacy. In US and in Europe, we've seen quite active enforcements by regulators, and in US, especially litigation as well. So this is our first webinar, which is more of a workshop type webinar where we are trying to get experts who can talk about how to solve these problems in a realistic scenario as well. And this is the first webinar as part of it. So as part of this webinar, the first topic is about top risk and latest enforcement in US. If you have signed up to this webinar, you will also have registrations for the next two parts, which will go deep into how a website actually functions in terms of technology and how you can use Privado to monitor it. Ali, if you can go to the next slide. Perfect. And to kickstart the webinar, hi everyone, I'm Vaibhav. I'm the CEO and co-founder of Privado.ai. Privado, for people who are not aware, is a product privacy management platform. We scan user-facing products like websites and mobile apps to discover any non-compliance or privacy issues like CCPA, banner not working, GPC signal not being honored, or health or sensitive data being leaked. Some of the things that Ali is going to cover in today's webinar from an enforcement perspective. Um, just some simple housekeeping items. We will record the webinar and the recording will be available afterwards. There is a Q&A tab that you will see below. If there are any questions at any point of time, feel free to put it there. I will be taking those up and asking Ali to answer those as well. We also have a dedicated Q&A time towards the end. So if there are any questions left, feel free to ask. We love how engaging our webinars are. So please ask all the questions that are top of mind. With that, I would love to introduce my panelist who's going to lead the workshop today, Ali Jasani. He's counsel at WilmerHale in the cybersecurity and privacy practice. And Ali, thanks a lot for joining in, and the content is amazing as I reviewed. So over to you for your introduction and the presentation.
Thanks, V, and thanks to Privado for having me. As V mentioned, I'm Ali Chasani. I'm counsel at WilmerHale, based in Washington, D.C. I'm in the privacy and cybersecurity group, and my practice focuses on a lot of the issues we'll be talking about today. So to dive into the substance, as those of you are aware that follow this area, data protection, litigation, and enforcement is on the rise. This has been true particularly over the past half decade. But it's changing rapidly, even more so over the last couple of years. And this is being driven by a number of factors. So primarily new legislative, regulatory, technological, and societal changes and shifts. So on the one hand, we have new laws and regulations, primarily at the state level. This includes the comprehensive privacy laws like the CCPA, but it also includes laws that are aimed at focusing on specific types of data or specific types of data processing activities, including children's data and consumer health data. There's also an increased focus by regulators on these issues. These issues have become more public and as a result have gotten more regulatory attention. So there's been specific attention focused on issues related to targeted advertising, biometrics, and children's data. There's also a trend of older laws being leveraged for new technology. So think about pixels and web trackers now falling under the purview of the California Invasion of Privacy Act. There are now video ads that are falling within the purview of the Video Privacy Protection Act. So we're seeing, this trend as well, where these older laws that weren't intended to apply in this context are now being applied as such, especially by courts and plaintiffs' lawyers. There's the rise of generative AI. AI and large language models have been all the talk over the past couple of years, and that has real privacy implications in terms of what data is collected, how it's being used, and for what purposes. This is another reason why regulators are paying more attention to these issues, and it's an intersection of both regulatory attention and companies engaging in new use cases that are now putting them within the purview of some of these data protection concerns. There's been a rise in security breaches and incidents over the past few years, which raises the risk of having a ton of sensitive data and the potential, the potential compliance obligations that come if that data is potentially compromised. And then finally, there are political realities, right? We had an election in the US that meaningfully shifts enforcement priorities for federal regulators, but it also makes states more likely to be an active player in this space. And all of that is relevant to how we think about these changes. So what does this mean for your business? I mean, these are the types of questions that companies that are, both at the heart of these issues think about, but also companies that previously didn't think of themselves as data companies should be thinking about. So one question is, how do you operate your business in an environment where the legal risks are constantly evolving? How can you engage in new and existing technologies while accounting for enforcement and litigation risk? One trend that I've seen is that a lot of companies, previously have had long-standing websites, and they haven't been aware of what trackers and pixels that their websites were using, right? This is a decision made by the marketing team without much input from the privacy team. And now, because of the rise in website related litigation and pixel related litigation, this is now a meaningful risk area for companies, especially if you're a company that processes what could be sensitive data, such as direct to consumer health data. And so this is where these new enforcement trends are having implications for pre-existing use cases, even though they don't necessarily implicate new technology. As I mentioned earlier, data issues are relevant for every company in some capacity, right? It used to be the case where companies could take the position where, like, we're not a data company, we don't process personal data, so we don't have to think about this. Our customers aren't consumers, so we don't have to think about this. But that's not how these laws work. Like California, for example, regulates B2B data, it regulates employment data. And so every company has employees, every company has business contacts. And so there are new rules that are relevant if all you do is engage in that space. As I was mentioning before, there are rules related to pixels and web trackers that are relevant if you operate a website. If you're engaged in email marketing or the use of text messages in a marketing capacity, right? There's CAN spam and the TCPA and international telemarketing rules. So every company is implicated by these rules in some capacity, and being able to properly gauge your risk in this area is a critical step. And that brings me to the presentation that for the rest of today, which is I'm going to talk about some of the enforcement and litigation trends that companies need to pay attention to from 2025 specifically. Again, this topic could be hours and hours, but I wanted to focus on some of the things that we've already seen this year that may kind of foreshadow what's going to happen over the next couple of years. So starting with the state comprehensive privacy laws. For those of you that are paying attention to this issue, you know that there are 19 states that have passed some form of a comprehensive privacy law. These are comprehensive in the sense that they're not limited to specific data categories or specific types of data processing activities, which is how we've regulated privacy in the US historically. They're laws of general applicability. So where they apply, they're intended to apply to all of a company's data processing activities. There are exemptions under these laws that are very relevant depending on your industry and what data practice you're engaging in. But again, they're intended to otherwise be comprehensive. There are many similarities between these laws, but also meaningful differences, and we'll talk about some of that. So one trend that we've seen in this space in particular is California, right? So California passed what was the first comprehensive privacy law in the US. What was the California Consumer Privacy Act? It was later amended by the California Privacy Rights Act. So they've been a leader in the privacy space at the state level for a long time, and they've done this with other laws as well. California passed the first breach notification law in the US, and now all 50 states have a breach notification law. So they've generally been a leader in this space. One of the other ways in which California became a leader was when the CPRA, the California Privacy Rights Act, passed. It created a new data protection agency, the California Privacy Protection Agency. This is the first true data protection authority we have in the US. Now, of course, we have the Federal Trade Commission and other regulators that enforce privacy, but this is the first privacy specific regulator we have in the US, where all they focus on are specific privacy laws. Up until this year, the CPPA, they've been focused on rulemaking under the CPRA, and under some of the other laws that now fall under their purview, including California's data broker law. Their enforcement up until this year really focused on data broker registration, like going after companies that fail to register under California's data broker law. This year, they announced their first two enforcement actions under the CPRA. One was a case against Honda for violations involving dark patterns, failure to comply with data subject rights, and selling data to ad tech companies. And another was against a clothing company, Todd Snyder, for failure to comply with opt-out requests and making it burdensome for consumers to exercise their rights. These weren't novel in the sense of that they involve like an expansive interpretation of the CPRA per se, but what they did do is show that the CPPA is going to be an active regulator in this space, and this makes sense for a few reasons. One is that this agency was specifically founded with the CPRA in mind, and so it would it would not be a shock at all if we see this agency being really active in terms of enforcing the law. We can contrast this with how the California AG's office, which used to have exclusive authority to enforce the old CCPA, they brought a handful under 10 enforcement actions during the law's first 3 or 4 years altogether. Now we can anticipate that this number is going to rise, both because we think the CPPA is going to be active, but also because the California AG's office still has enforcement authority. So there are essentially two regulators that are in charge of enforcing this law. So in terms of what to pay attention to in California looking forward, as I mentioned earlier, future enforcement actions are likely, including from the California AG's office. The CPRA does have a private right of action, but it is limited. It's intended to apply to security incidents and not to the law's privacy violations. It's a weird provision because other than requiring reasonable security, the law doesn't really create any specific security standards as of now. But we have seen plaintiffs' lawyers try to expand the scope of the CPRA by trying to bring privacy violations under the private right of action, under the theory that, for example, like an unauthorized disclosure is actually a data breach. They've had some success, but limited success so far under that theory in California courts. There are new rules under the CPRA that are being worked on right now by the agency regarding automated decision-making, cybersecurity audits, and risk assessments. And there's also rulemaking under the Delete Act, which is a law that modified California's data broker law, which is going to create the eventual adoption of a universal opt-out mechanism. So what that's going to mean is if you're a company that's registered on the California data broker registry, eventually you're going to have a technical solution that allows you to recognize that allows you to recognize an opt-out that a consumer submits through that website. This doesn't go into effect until 2026, but it's going to create meaningful challenges for companies, both because it's going to require this technical solution, but it's also going to substantially increase the number of opt-outs that companies are going to get as a result of making it so much easier for consumers to opt out. Right now, consumers have to go to each individual company to opt out of their data, the sale of their data, or to delete their data. This is going to change that on its face and going to make it a lot easier for consumers to exercise their rights. Another regulator that I want to talk about is the Texas AG. As I mentioned, California has been a leader in this space historically. Perhaps no regulator has been as active on privacy enforcement over the past year as Texas. So just a few examples here. They had a settlement with Google for $1.4 billion for alleged misuse of biometric data. This settlement happened just a couple of weeks ago. In December, they launched an investigation into numerous companies for alleged violations of children's data. Earlier this year, they launched an investigation into multiple connected car companies for alleged misuse of not just children's data, but generally data involving connected cars. And then they had a settlement last summer with this company called Pieces Technology for alleged AI violations. This was a health data company, and they alleged that the company's use of AI led to unfair or deceptive acts or practices. I think the Texas AG, it's a good example of a regulator that is using all of the tools they have at their disposal to bring privacy cases. So Texas has a children's data focused law called the Scope Act. There is a biometric privacy law in Texas. There is a comprehensive privacy law in Texas. And then Texas, like every state, has a general unfair or deceptive acts or practices law. And the Texas AG is using all of those tools to bring enforcement actions. Comprehensive privacy laws that I want to talk about specifically is Maryland. And it goes into effect later in 2025. The reason why Maryland stands out to me, I mentioned that a lot of these laws have a lot of similarities. Maryland really stands out because it has a very strict data minimization standard. So most of the comprehensive privacy laws generally require data to be processed for the purposes required or requested by the consumer. The exact language tends to vary. Maryland's data minimization standard says that you can only process data that's strictly necessary for the products and services requested by the consumer. And that's quite meaningful, right? Because that potentially implicates use cases such as using data to train AI models, or using data for targeted advertising purposes, or other secondary purposes. Those might be outright prohibited under the Maryland law. It's also meaningful in a number of other ways, including a prohibition on the sale of sensitive data, and then prohibiting data controllers from data uses that result in discrimination. One of the other categories of laws that are relevant, especially as companies think about future litigation risk, is Washington's My Health, My Data Act and other laws that are similar to it. This passed in 2023 as a major new category of a privacy law. It passed quickly, at least partly in response to the Dobbs decision, which overturned Roe v. Wade. It's meaningful for a couple of reasons. One, it has broad reach beyond traditional healthcare entities. So, if you're, a health insurer, a healthcare provider, you've already been thinking about health privacy because of HIPAA. This makes it so companies that have fallen outside the scope of HIPAA now have a set of rules that apply to them specifically. Of course, the comprehensive privacy laws also apply to that landscape. But now, this is intended to specifically target non-HIPAA health data. It's also meaningful because it has a very broad definition of consumer health data. So it's not just things that you would traditionally consider health data, like prescription data or information about medical conditions, but it could include things like purchase data and inferences and other things that are associated with non-health data. So it has the potential to capture not just things like your Apple Watch, which probably collects a ton of health data about you, things that you would directly consider health data, but it could also implicate grocery stores to the extent that they're making inferences about a person's health that's associated with non-health data, such as a person's purchase history. The other meaningful, what makes this law meaningful in terms of a new privacy law, is that it does have a private right of action. So a lot of the ambiguities in the law are not going to be played out in, through regulatory enforcement actions, the regulatory guidance, which is what we normally see. We're going to see these played out in court because of the law's private right of action. It has inspired copycats. One law in Nevada in particular passed soon after, and it's almost identical to the My Health My Data Act, although it doesn't have a private right of action. And there are other laws that are more focused on reproductive data that are passing that are substantively similar to My Health My Data Act, and we'll talk about at least one of them in a coming slide. So the first publicly, and one of the reasons I want to talk about this in terms of 2025 trends, is that the first publicly available class action complaint was filed under the My Health My Data Act earlier this year against Amazon. It alleges that Amazon's software development kit, SDK, embedded in a third-party mobile application violated both federal wiretap laws and state privacy laws, including the My Health My Data Act. According to the complaint, the information, the consumer health data that was processed pursuant to this activity was, precise geolocation information, mobile advertising IDs, and other location data that could reveal sensitive health information. I think this complaint is notable for a few reasons. One, how broad consumer health data is defined under the rule. So it theoretically could include all of these categories of data, even though the question is ultimately, right, is the geolocation data ultimately consumer health data, which is a fact-finding question, and there's cost to, like, even if the company here ultimately prevails on the merits, there's a cost to being subject to such a lawsuit in the first instance. The other piece that's notable is that this involved a software development kit. This is an area that we are seeing a ton of litigation and enforcement. Website, like the things that companies are using on their websites, on their mobile apps, and not being aware of those, or being aware of those and not accounting for the fact that they may trigger some of these laws. This is just a high risk area for companies in general, but particularly if you associate them with sensitive data. I mentioned that there are these laws passing that are very similar to Washington, albeit somewhat narrower because they focus on reproductive privacy in general. So Virginia recently amended its general consumer protection law to include a consent requirement for the obtaining, disclosure, or sale of what it calls reproductive or sexual health information. Now, this term is defined broadly enough to include things like purchase level data. So the mere fact that someone purchased a Plan B pill could be subject to the scope of the law, even if you didn't do anything else with it. So even if you didn't draw an inference about someone's purchase of that data, just the fact that they purchased that data could be subject to the scope of the law. The other piece that makes Virginia unique is that there's no exception for data processing that is necessary for a product or service requested by a consumer. So even Washington has an exemption to its consent rule that says, hey, you don't have to get consent if what the consumer is doing, if what you're doing is providing a product or service requested by the consumer. There's no such exception in the Virginia rule. And it has a private right of action. It was signed into law earlier this year, and it goes into effect in July. So you can imagine some of the operational challenges this is going to create for companies that operate online websites where they sell data information that could potentially be subject to the Virginia law. And it's not just limited online; it could also apply to brick and mortar stores that may have to comply with this consent requirement as well. One theme that I've mentioned throughout is the class action risk for tracking technologies. I mean, this has been an area of focus for plaintiffs' lawyers, using for cases involving pixels and web trackers, including on websites, applications, and video advertisements. So the various theories of liability are things like the California Invasion of Privacy Act. There are other state wiretapping laws that are also being leveraged for this purpose. These tend to be laws that have these laws exist in all 50 states essentially, but the laws that are being implicated the most are laws that tend to have two-party consent requirements. And the idea is that the pixel or web tracker is recording the consumer without the consumer's consent, thereby violating the wiretapping law. Again, these are laws that are from the 50s and 60s, intended to apply to a very different contexts that are now being leveraged in this specific context. Another law where that's happening is the Video Privacy Protection Act. The VPPA passed in the 80s, and it was intended to protect your information that Blockbuster may have about you in terms of like what videos you're renting from Blockbuster. Now it's being applied in these class action lawsuits against companies that are using certain trackers in relation to video advertisements. So again, there's a whole trend of older privacy laws now being leveraged for new use cases. One of the things that I want to talk about that is on a lot of companies' minds, that where there hasn't been a formal enforcement action yet, but there's been enforcement guidance already, are new data transfer rules, specifically the DOJ bulk data transfers rule. This rule came out of an executive order that President Biden signed last year, and that DOJ turned into a rule that was finalized in December. But what it does is that it restricts data transfers involving data brokerage. It prohibits those transfers to the extent that they involve bulk sensitive data to identified countries of concern, which include China, Cuba, Iran, North Korea, Russia, and Venezuela. The way that the law defines data brokerage is quite broad. So when we think of data brokerage in the traditional US state privacy context, there has to be an indirect relationship by a company. The company collects the data indirectly from consumers and then sells the data to third parties. That's not how the DOJ rule defines data brokerage. It says that the recipient if the recipient doesn't have a direct relationship with the consumer, then that transaction is considered data brokerage. So what that means is, for example, you could be a US company, a US website publisher that collects information about your website visitors, and then host that data in China for analytics purposes or for data storage purposes or whatever it is. And you could then that would be considered data brokerage for purposes of this rule that is prohibited by this rule. So that's one way in which this rule stands out, is that it's quite broad in terms of its scope. And not only, and you may think, oh, we don't engage in this process in China or Russia, we don't have to think about it. One thing to think about is that this rule includes Hong Kong within its definition of China, and most businesses have traditionally thought of Hong Kong as different than mainland China from business perspective. So that may be where it's relevant. And this rule's applicability isn't relevant to those countries. If you're an entity that engages in data brokerage with any foreign entity, you are prohibited from engaging in that transaction unless you have certain contractual prohibitions in place that prohibit the onward transfer of that data to the countries of concern. So at the very least, this requires all companies that engage in data brokerage internationally to modify their contracts and include certain contractual protections to fall outside the scope of this rule. And you may say, okay, well, I don't engage in, I may be involved in these countries, but I don't engage in data brokerage at all. I just have a vendor relationship. This rule also implicates vendor relationships, employment relationships, and investment agreements. Those transactions aren't prohibited by the rule, but they are restricted, and they're subject to strict cybersecurity and auditing and diligence requirements. The rule went into effect on April 8th of this year. On April 11th, the Department of Justice came out with guidance basically saying that they were going to give companies leeway if they acted in good faith. They were trying to comply with the rule, and that for the time being, for the next 3 months from that time, they were only going to focus on willful violations of the rule. The other piece that makes this rule stand out is that it doesn't just have civil penalties, it also has criminal penalties, which is a meaningful deviation from other privacy laws. So to wrap up, the key takeaways here is that privacy law is continuing to evolve. It is intersecting with other areas of the law, including laws that are regulating AI, laws that are driven by national security concerns, such as the DOJ rule, and other concerns like related to health data, for example. As I mentioned up top, every company has privacy and security compliance obligations. If you think you don't, you aren't looking hard enough, or you aren't thinking about them holistically enough. Because again, every company has employees, every company has business contacts. There are international considerations, there are marketing considerations, there are website pixel considerations. These are relevant for all companies, and all companies need to be thinking about these issues. But if you are a company that operates in a regulated space, or if you process sensitive data, your risk is just higher. And that doesn't mean you can't operate your business, but it increases the importance of proper due diligence. And one theme that I want to touch on is that it used to be the case that websites were operated by the marketing team and privacy didn't have input. Employee data issues were handled by the HR team and they didn't run across privacy. This is all changing. And to the extent that data use cases are involved or implicated, including the use and development of AI, or the expansion to new markets or whatever it is, these all have privacy implications. And to the extent that they, even if they're driven by the business team, privacy needs to be involved in these conversations to at the very least the team can properly understand what the risks are. And with that, I'll turn it back to V.
Awesome. Well, thanks, Ali, for such an amazing presentation. I was constantly taking notes, so I have a ton of questions, and you touched, I think, across the state lines, all type of regulations and enforcement actions. So great presentation. Thanks for that. We already have a bunch of questions, so I'll reserve my questions towards the end. If anyone in the audience has questions, please use the Q&A button below and start asking questions. With that, I'm going to start firing those questions towards you, Ali. The first question is, other than California, do we have any examples of other states where wiretapping laws are being used to initiate class actions?
Yeah, absolutely. There are, I think, over 10 states that I mentioned have two-party consent. Like a couple examples are Pennsylvania and Massachusetts. There was actually a pretty notable court case in Massachusetts where the Massachusetts Supreme Court said, hey, this wiretapping law wasn't intended to apply to pixels. And so it was a big win for defendants in this space, but that's just one court, that's just one state. There's still a number of other states that have these rules.
Awesome. Another question is, how can a company know for sure that information is truly anonymized or de-identified when the pixel data is shared with a third party?
Yeah, that's a great question. I mean, this is something that comes up all the time because, a lot of these vendors will say, hey, we only get anonymized, de-identified, aggregated data, right? And there's a few points there. One, anonymized and de-identified data have specific meanings under these privacy laws. So it's not, we can say, oh, you're removing one identifier and then it's fine. It's like, that's not necessarily how de-identification works, especially not if you're in a regulated space like HIPAA, where there are very specific de-identification methodologies. So that's one point there. The other thing that I've come to realize is that the way marketing and non-privacy folks think about data is very different than how data is regulated. I can't tell you how many times I've had someone tell me, well, we don't collect PII, but you collect IP addresses, MAIDs, you collect all these things that are regulated as PII in data protection law, right? Like, so that's not how people have historically thought about PII, but that's not what the definition of personal information is. So to answer your
Right.
question, I think it's important to do due diligence on what exactly is being collected and what it's being used. If you're relying on de-identification or anonymization, it's worth asking about the methodology, and it's worth getting contractual protections, right, to make sure that you're protected in the event that the vendor is not taking the appropriate steps to de-identify.
Absolutely. And to add Ali's point, like most likely if you have a pixel, they are always getting personal data, personal information, because the way they are supposed to work is to retarget on different platforms. And if they can't track you with an ID, then the whole point of the pixel goes away. So yeah, most likely there will be. So we have a few more questions. So there's a question from the European side wherein they're asking, as a Europe-based DPO, we usually apply strict GDPR adherence to companies acting in or even stationed in the USA? How do these laws differ from requirements that are already in place in the Europe under GDPR?
Yeah, that's a great question. I mean, it's funny because, for example, thinking about cookies and pixels and trackers, like the US generally doesn't require a cookie banner, right? That tends to be an e-privacy law directive requirement. At the same time, what you're seeing is a lot of US companies will proactively put cookie banners because it's helping them have a defense in the SIPA litigation cases and whatnot. So, I mean, the GDPR gets you a lot of the way there for a lot of these things, and we're seeing even the US companies who aren't subject to the rule apply some EU standards. But EU and US law are different. Like California, for example, has very specific disclosures you have to put in your privacy policy and like very specific words you have to use. Same in your contracts with your vendors. So it's not so the mere fact that you're using, if you use the GDPR language for both of those things, that may not be good enough. Now you can say, okay, like, it's 90% of the way there. And so that should be fine. Maybe, but for another example would be California requires you to have a do not sell or share my personal information link at the bottom of your website. There's no equivalent GDPR requirement. And so thinking about something like that is, that's where US law, quote unquote, goes further than the GDPR. I mean, look, it's a different question of whether this is a good thing to have or not, but it is meaningfully different, right? So just relying on the GDPR without specifically thinking about US privacy laws may not be good enough, depending on what you're doing.
Awesome. Thank you. The next question is, you mentioned DOJ will only prioritize willful non-compliance. Is this a temporal or a temporary position, or you think it'll be the approach going forward due to limited resources?
They said the willful stuff will be until July. Now, I do think that there's, I mean, and this is not just you, this is how all regulators think, right? If you're egregious about some of the activities you're engaging in, you're just in higher risk, right? Um, so I do think that's going to be they're going to focus on low hanging fruit, the easier cases early on, I think. With that being said, as I mentioned, like this law has criminal liability. So, one thing that I do with my clients, and like any good privacy lawyer does, is weigh risk, right? And I like to think of myself as pretty good at doing that. But it's really hard for me to say, well, the risk here is that you'll be taken out in handcuffs. Like that's a very different thing for me to evaluate in the day-to-day course of, and it's something I'm struggling with, right? Like, and so that's another reason why I've seen companies that otherwise wouldn't be top targets for this, otherwise are engaging in normal, not egregious activities, are still prioritizing DOJ rule compliance.
Yeah, makes sense. We have a few more questions. So yeah, if there are more thoughts coming up, feel free to keep adding. We will extend if we need to for a couple of minutes. The next question is Google Analytics, I mean, this is a classic question. Is Google Analytics a vendor with Pixel and Tag Manager? Will Pixel and Tag Manager be considered as sell/share data under the California regulation?
I mean, that's a question for the regulator. I don't know. I mean, I don't know how they're going to think about that. My understanding is that Google has different modes. Like Google Analytics, there's like a CPRA compliant mode that you can use, and maybe
Absolutely.
that's fine. I don't know if the CPPA is going to have that. Just again, just because Google takes that position doesn't mean the regulator is going to take that position, right? So it's hard for me to say where they're going to come out on this. But if you're using that mode, that at least provides you with a defense. And look, a lot of companies use Google Analytics, right? It's not like you'd be the one standing out here. So I think it would just depend on how the regulator thinks about it.
Yeah, thanks. Thanks for answering that, Ali. Just one caveat there. What we've observed in our audits of websites through our product is the Google consent mode, which is non-personalized advertising, is usually misconfigured, which means while you might say you're using the right mode for defense, but if the signals are wrong, then Google will treat it as an advertiser law. So you should check if you're sending the right signals as part of this CCPA mode for even Google Analytics. Um, so the next question is, if my privacy policy clearly states we do not sell personal information as defined under CPRA, do I still need to include do not sell or share my personal information disclosure in my cookie banner? Very
Uh,
specific, but any
yeah,
guidance?
I mean, generally, no. I mean, if it's actually true that you don't sell personal information, then you don't need to include a do not sell link. I would, make sure that that's actually true. Like, like the way that the law defines sale is quite broad. So, proper due diligence on that point is important. But, if you can reasonably reach that conclusion, then no.
Yeah, and also share, right? Basically, any advertising, contextual
Yeah.
advertising would, and that keeps changing. So you might not have the shared use case today, but maybe in the next few weeks, someone in your marketing decides like, hey, we just need a TikTok pixel to retarget, and suddenly you do need that. So it's dynamic, is what we've seen as well. So the next question is like guidance on if there's any link or website to learn more about which US privacy laws have private right of action. If you have a resource of Wilmer Hale, feel free to point out. If not, that's fine.
Yeah, we don't have. There's nothing. Yeah, I would say go to outside counsel for that. That's not done early on. I mean,
All right.
it's just like there are. It's tricky because there's like, for example, there's like state laws that regulate specific health conditions that may have a private right of action. So it really does depend on context, right? It's like there's a lot of laws that have a private right of action, but not all of those laws are relevant to a business. Like, and so you have to think about what you're actually doing, and what laws may be relevant to you as part of that processing activity.
Makes sense. And then we have the last question here. So yeah, anyone who has more questions, please put it in the Q&A section. So the question is, what are best practice steps for harmonizing a global privacy policy where an entity is subject to multiple privacy jurisdictions? So think US has, as you said, like multiple state laws, then there is Europe, maybe China, India as well.
Yeah, I mean, look, I can't speak to every single jurisdiction. I can say that like when I have a client that is subject to the EU and the US, for example, I generally feel comfortable grouping the other 18 states in the US together. I'll include those as part of the single disclosure in the privacy policy. I usually treat California differently because it does require specific words. Um, and I also, and then for the GDPR, same thing. I can kind of treat that. The GDPR does require specific disclosures, but I feel comfortable enough to include them in the body of a general privacy policy. I think it's I think it's tricky, right? Because for example, like Washington, if you process consumer health data, they arguably also require a separate privacy policy. And so like that creates another compliance obligation. And so some of it is like, weighing the risk also. And in terms of And one other thing to think about in terms of all of these specific requirements is you also can't engage in dark patterns. So you can't make it so the policy is so confusing to consumers that it's useless. And so you have to balance all of that at the same time. And look, it's quite hard, but you know it's the cost of what we're doing here.
Absolutely. Okay, last few questions. I know we are on time, but I'll try to ask the last two. So there's one question around, are we seeing any litigation or enforcement of GPC controls, global privacy controls, specifically in California and or Colorado?
I haven't seen Colorado. I think California's. I think it was the AG's office. They did have at least one enforcement action where the opt-out preference signal wasn't being honored, and that was part of the enforcement. I would think that this is going to be a priority area for the state regulators.
And I think Todd Snyder also, they had mentioned GPC control, as far as I remember. I'm not fully sure. Um, Okay, the last question for you is in terms of okay, I think the chat it got removed, but the question was like if do not sell or share, and I think this might be an easy one, redirects to another page, and if on that page additional data is required to process the do not sell or share request, is that allowed or is that a compliance issue?
I mean, look, again, I don't know the rules off the top of my head, but they generally, they're generally against asking for more information. But if you need to, like, it depends on, like, for opt-outs, the standard is generally lower. So the default in California is for opt-outs, you should just opt out the consumer. Like, there's not their thinking is like there's no theoretical benefit to the consumer, so you should just abide by the opt-out. There's a higher standard for things like access and deletion requests because, for example, like, it harms the consumer. Like if you just comply with the right to access request without verifying the consumer's identity and that turns out to be fraud, that's bad for the consumer. And same with like a deletion request. If I have, my account with Apple and I can just delete it if I accidentally hit one click, like that's bad for me. Then I just lost all of this, history I have with a company that I'm associated with. And so there's a higher standard for those compared to opt-outs, which are subject to a lower standard.
Awesome. Perfect. Well, last question, Ali, and then we'll call it off. Is there any signs that a California court will follow? I think it's mass and rules. CPA doesn't apply to cookies or pixels.
Um, Nothing that I've seen. I mean, there's so much litigation on this space. And I think it would have to be in the California Supreme Court. I mean, I'm sure there are lower courts that have interpreted more narrowly, but I don't think we've seen anything from the California Supreme Court on that position yet.
Awesome. Well, that concludes all the questions, Ali. I had like 10 more questions, but never got to reach there. But thanks a lot, Ali, for joining in and giving a wonderful presentation. I think I learned a lot. I'm sure the panelists did as well. We can see that from all the emojis that are coming in, all the messages which are coming in. And thanks everyone for joining in. We'll be sending the recording of the webinar later as well. Thank you. Bye, everyone.